So, as has been mentioned, I'm going to talk about business immigration to Canada. You have heard about InterJurisconsult, Canadian immigration firm that specializes in business immigration. And we will talk about this exciting topic today. So this is the agenda for today's presentation. I understand that we are probably a bit limited by time, but we'll try to get through it as quickly as possible. I'll first talk about the relevant departments and agencies that deal with immigration to Canada. I'll talk about temporary entry to Canada, about permanent residence in Canada for those who decide to transition to that option. I'll talk about inadmissibility issues, and also we'll talk about obtaining immigration status for family members of those who decide to come to Canada to join the business people who would like to move here. And then I'll be happy to answer any questions that you may have at the end of the presentation. So the agencies that deal with immigration matters, Immigration, Refugees and Citizenship Canada, formerly known as CAC, Citizenship and Immigration Canada, as well as Canada Border Services Agency, CBSA. Those two agencies were in the past one agency, and then they split. IRCC currently deals with immigration matters, and CBSA deals with enforcement matters on the immigration side. Of course, they deal with customs and many other matters, but in the immigration context, that's what they do. And also, when you come to Canada, you would likely meet a CBSA officer who will be deciding on your admission to Canada. The other department that's relevant is Employment and Social Development Canada, that is ESDC, that deals with such matters as deciding whether approval should be given to a foreign employer to hire foreign workers. And on that basis can be a foreign worker can apply for a work permit, but we'll talk about that in a moment. The other departments that are relevant, immigration departments of individual provinces and territories that have created such departments in order to select suitable candidates for immigration to those provinces. And they have corresponding agreements with the federal government of Canada, giving them that mandate. And it needs to be mentioned that immigration is is within federal jurisdiction, but they do cooperate and listen to the province and territories' needs, as they know best what they need. So we will talk then about business visitor criteria. Many people want to first come to Canada on business to explore business opportunities, or they might already have some business mandate or program, and they would like to conduct certain activities in Canada. It's very important to make sure that people who seek to enter Canada as a business visitor do not enter Canadian labor market, and they should not be gainfully employed in Canada. It is expected that their activity is international in scope, and that there is a presumption that they have a foreign employer that is based outside of Canada, and that they are remunerated by such employer outside of Canada, and the employer's business is outside of Canada as well. Main principal place of business outside of Canada. We then should talk about more specifically about business activities. So what's allowed for business visitors? Activities such as buying goods or services for foreign entity, attending meetings, seminars, conferences, trade shows, exhibitions, and so on. What's not allowed is providing services in Canada, competing in the Canadian labor market, and any activity for which there would be a remuneration from Canadian entity. So they can be paid by foreign entity, but not by Canadian entity. Canadian government has recognized that there is a global competition for top talent around the world. And in order to make Canada more attractive to businesses, it created the global skill strategy that allows people, companies, businesses to bring foreign workers to Canada much easier than prior to this initiative. Under this, it's important to, there are two main distinctions. One is highly skilled workers, and the other one researchers. Of course, the most commonly used and most widely used is the category of high skilled workers. They tend to be, well, they have to be in the level O or A under the National Occupational Classification. And they can be admitted to Canada for 15 days, once every 6 months, or for 30 consecutive days, once every 12 months. Now, this doesn't mean that they would be accepted for 15 days under the 6 months rule within 6 months, and then for 30 days. So it's one or the other, can't be both. The other thing that the government expects is that this should not be used as provisions should not be used as a stepping stone into something more significant in terms of foreign workers' presence in Canada. So there may be an urgent need to bring somebody here, and the employer might intuitively think that, okay, well, we'll probably use this category and then we'll transition to something else. They expect the employers to be open about the and transparent about the needs for their foreign workers' presence in Canada, and they expect them to follow the right procedure from the very beginning. Now, so the other category is researchers that would be expected to perform research in Canada at a Canadian publicly funded a degree granting institution or its affiliated research institutions. Such people can enter Canada for a period of up to 120 days, once every 12 months. Just elaborate on this further, the government created processing timelines that are relatively quick under the global skills strategy. That is 2 weeks processing time. The requirement for LMIA exempt work permits is that the occupation should be at level O or A, and the employer must submit an offer of employment through the employer portal, and pay the employer compliance fee, which is $230. And the foreign worker would apply for a work permit outside of Canada. Under the LMIA-based work permit, under this global skill strategy, the employer would first have to obtain a labor market impact assessment, LMIA, through Global Talent stream of the Temporary Foreign Worker Program of Employment and Social Development Canada, ESDC, otherwise also known as Service Canada. Then the foreign worker, if the LMA gets favorable consideration and is approved, then on that basis, a foreign worker can apply for a work permit, and that application also needs to be submitted outside of Canada. I mentioned earlier LMIA, Labor Market Impact Assessment. Under LMIA, there are different streams, and the ESDC department, Service Canada, also a Canadian government department that works closely with the Immigration Department, IRCC. They also created Global Talent Stream to facilitate assessment, quick assessment and streamline assessment of the needs of employers to bring talented foreign workers, highly talented foreign workers to Canada on an expedited basis. To benefit from these global talent stream, a foreign worker the employer must be referred to Service Canada or ESDC by designated partners under Category A of this program, or otherwise the occupation must fall under Category B on the occupational list of global talent occupational list. That list is comprised of mostly technical occupations, computers, programmers, computer engineers, software engineers, and so on. Now, if the employer finds that the position that they're trying to fill in Canada does not fit the requirements of global talent stream, they can look at the general LMIA categories, which fall under a high wage stream and low wage stream. However, under this category, there is no expedited processing, and it needs to be mentioned that on the global talent stream, the Service Canada Department, ESDC, would be happy to process the application within 10 business days. And so combined with the work processing, that basically means that within a month, a foreign worker potentially could come to Canada after the 2 weeks process for LMIA and then 2 weeks process for work permit. There are certain requirements that need to be met for each in order to benefit from this expedited process, but that goes beyond the scope of today's presentation. So if the employer would have to consider general LMIA categories, then the process will take significantly more time and may take many weeks. There will be a requirement for the employer to prove that they've conducted recruitment efforts and that they could not find a qualified Canadian citizen or permanent resident to do the job, to fill the position. And in the context of the application for LMIA, they would have to submit a transition plan with the mandatory and complementary benefits to the Canadian labor market, and it's subject to negotiation between the employer and the department to satisfy the department that the employer will do everything possible to make sure that the recruitment and the hiring of this foreign worker will have a positive impact on labor market through those mandatory and complementary commitments. It needs to be mentioned that in addition to if the position is in the province of Quebec, in addition to LMIA, the employer would have to, there will be a requirement for filing and getting approval of acceptance certificates, CAQ, which must be submitted to Quebec's Ministère de l'Immigration, de la Francisation et de l'Intégration, MEFI, or MIFI in English abbreviation. In terms of work permits, so we talked about the LMIA and LMIA exempt work permit briefly in the context of previous priority categories for Canadian government. So more specifically, the LMIA-based work permits for business professionals will have to be, again, submitted either through Global Talent stream or through the general category to Temporary Foreign Worker Program of ESDC, and then prospective foreign worker would have to apply for a work permit. Now, the LMIA exempt work permits very broad. There are many different categories for business persons, and there they would have to be fallen within the category level O, A, O, B of National Occupational Classification. The employer must submit an offer of employment through the employer portal, pay compliance fee, which is $230 as mentioned, and then the prospective foreign worker would be submitting a work permit. Now, this work permit can be submitted outside of Canada, or if the employee, the foreign worker is already working, if it's an extension, for example, that application can be submitted inside Canada. But again, there are many different varieties of situations, and we'll not go into all of them. Temporary entry under international mobility programs. So there are international agreements that Canada entered into with multilateral partners and different countries, and also it has bilateral agreements. So multilateral agreements would be such as General Agreement on Trade and Services, GATS, Canada, United States, Mexico Agreement, CUSMA, as we call it in Canada, or old NAFTA, as most commonly known for many, many years. It's renegotiated agreement, and it mirrors to a great extent the previous NAFTA agreement. Canada European Union Comprehensive Economic and Trade Agreement, CETA, then that is basically between member states of European Union and Canada. I need to mention that the first one, the General Agreement on Trade and Services, GATT, is for countries who are basically members of the World Trade Organization. In terms of comprehensive and progressive agreement for Trans-Pacific Partnership, those has a significant number of countries as well. Some Latin American countries are part of it: Mexico, Chile, and Peru. Canada is part of it. New Zealand, Australia, Brunei Darussalam, Malaysia, Japan, and Singapore and Vietnam are parts of this agreement as well. United Kingdom has expressed its strong interest in joining CPTPP as well, and the negotiations, I understand, are ongoing and will be started very soon. And so that will broaden the scope of that agreement or the membership of that agreement, and provide opportunities for mobility of business persons and professionals as well. It is anticipated that Britain will also potentially commit itself to such mobility. And then, so all of these mentioned so far were multilateral agreements, and bilateral agreements between Canada and foreign countries include agreements with Chile, Colombia, Panama, Peru, and Korea. We have, I understand, quite a number of today's participants in today's program from Peru and from Colombia, and I believe there were also some from Chile and Panama. So the bilateral agreements also have, all of these agreements have mobility provisions, and that's why they're mentioned here. There are some other agreements that don't have mobility provisions, free trade agreements that don't have mobility provisions, and that's why they did not make it to this list that I'm presenting today. In terms of categories, the main categories under this agreement would fall under intercompany transferees, professionals and technicians, and traders and investors. Quite often, the employers, foreign employers, intending to transfer foreign workers to Canada, to Canadian business, would look at intercompany transfer or transferring professionals, technicians, for example, in various categories. Under intercompany transfer, those can be executives, senior managers, specialized knowledge workers, and in some cases, functional managers. Work permits for business professionals under Canadian interests. So there are LMA exemptions for under various provisions, and some of them I've just mentioned, and we will go through some of them again in more detail. So significant benefit, entrepreneur, self-employed. This category, I would say, is not widely used because of its complexity, and because quite often there are other options that can be pursued. And it is, in a way, the category of last resort. If nothing else works, then one can look at that category. Then there is intercompany transferees, executives, senior managers, functional managers, specialized knowledge workers. Each has their own rules and requirements. And again, we are pressed by time, so we'll not go into details of each of them. Quite often, businesses will need to bring repair personnel for out-of-warranty equipment, and it's understood that those people should have easy access to Canada to perform that type of work. The other priority category is television and film production, and workers from in that industry can benefit from this LMA exemption as well. Another very popular category is francophone mobility. Again, it's also LMA exempt category, and the requirement for that category has many requirements, but one of the main things is that the person should have a very high level of ability to speak French, communicate in French, and it doesn't mean that the person needs to be francophone per se, meaning born into French-speaking family and have French-speaking background. It can be a person who has mastered French to a very high level and uses French in daily life, and that can be sufficient for such person to fall into that category and benefit from LMA exempt process for a work permit. So essentially, the employers that want to transfer foreign workers, and if they can find an LMA exempt category, of course, it's preferable to pursue such category because it eliminates an extra step of seeking LMA confirmation, and they can proceed straight to the work permit application stage, which in some cases can be relatively quick. Okay, in terms of so far we talked about temporary entry of foreign professionals and business people to Canada. Some of these professionals might want, and the business people might want to transition to permanent residence. Canada is a fantastic country, as we heard from a number of panelists today, from Ambassador Bidar and other presenters as well. And I hope by this time you're convinced that this is a great place to not only do business, but potentially live long term as well. Now, in terms of categories for permanent residents, there are a great number of those categories, but I've listed some of the most popular ones that are used by business people, and not in a particular order. But we'll start with startup visa. Startup visa was a very popular category, and it was used by many employers, by many innovative people who have innovative idea and wanted to start up a business in Canada. There is a requirement that they would need to create a job for Canadians, and this enterprise should have a chance to compete globally. So, you know, sort of the likes of Microsoft and Google, if somebody like to create those type of companies in Canada, Canada of course would welcome them, but it doesn't have to be that big. Anything innovative, something that has great potential would be considered. There is a requirement, however, to sort of partner with the approved institutions. And how that's done is that they would need to get a letter of support. So they need to have a business mind in Canada that can be completely new business that would be starting here, or they can take over and then create on that basis if there is that possibility. But most people choose to start their own business from scratch in Canada, or create a subsidiary, for example. So in terms of requirements, so there is a language requirement as well. They need to have some money to support themselves initially. But perhaps one of the most challenging parts is to secure a letter of support from either venture capital funds or angel investor groups or business incubators. And out of these three, the most popular option is to go through an incubator. And there are many different incubators, there are many different approved organizations that would support such potential inventor who would like to set up go through startup visa program and start up innovative business in Canada. and they all have different requirements. Now, in terms of what I mentioned, that it was very popular program in the past, it's became a victim of its own popularity, I should say. It's oversubscribed. A lot of people, significantly more people than there are available places in that program in terms of annual quota, and that has caused delays to processing of applications under that program. However, once there is a letter of support in hand from the qualified organization, a person can apply for a work permit if that person is considered to be essential person to the business. And so if one finds that there are no easier pathways to permanent residence for such entrepreneur, startup entrepreneur, for example, they could consider going through startup visa and then transition to a work permit in the interim while they would wait for the decision on their permanent residence application. So that could work. Now, the next category I'd like to talk about briefly is self-employed. That category is for people who want to start a farm in Canada, who want to potentially set up a business in the area of sports, culture. Again, that category is not widely used because it takes significant time to process. We're talking years. And again, it's possible to apply for a work permit in the interim as well. It's not easy to obtain work permit for those applicants, at least not as easily as for people who apply under the startup visa stream. But it's a category that many people have been applying for many years, and that program still exists, unlike a federal program for entrepreneurs that was phased out. The probably most popular program these days is a program on, a most popular system of applying for permanent residence is Express Entry System, which has 3 different programs. Skilled worker program, Canadian Experience Class, and Skilled Trades program. The foreign workers who are not in Canada would normally apply through skilled worker program. Some might consider a skilled trades program, but that would be difficult to qualify if they don't have Canadian experience. But the most popular program for those who are already in Canada working and have Canadian experience at certain level would be Canadian Experience Class. And during the pandemic, Canadian government has been actively inviting people to apply through this category, and the threshold for invitations to apply for this program through this system has been is currently lower than in the previous years. The way this program works is that the candidate would have to create Express Entry profile and then wait for an invitation to apply for permanent residence. And if the applicants would be competing against each other, basically for nomination or for invitation, and that would be based on their relevant immigration factors, and the government will decide at what threshold they would like to issue the invitations, and all those above that threshold, meeting the threshold above, would be receiving invitations. After that, the applicant would submit application for permanent residence, and once the application has been consideration has been completed, the applicants will obtain permanent residence. There are programs, so all of these were federal programs, and as I mentioned, there are many other programs, but these are the perhaps the most popular ones for business people. There are other programs under the programs of provinces and territories. There are business programs, there are skilled worker programs, also skilled trade programs, and some other types of programs. Going through the provincial nomination or nomination by territory would add an extra step in the application process for permanent residence, because the applicant would have to obtain nomination by the province or territory first, haven't fulfilled all of the requirements of that province's program. And the program, as I mentioned, they have quite a number of programs. And then apply for permanent residence through the federal, by submitting the application to federal government. The final say on approving immigrants to Canada lies with the federal government, and they decide who should be admitted to Canada in the end. So in terms of strategy, obviously, it's better to reduce number of steps, and if possible, to qualify under the federal program straight. It's probably better. Otherwise, one would have to go through one can consider provincial program. Needs to be mentioned that if a person resides or intends to live in Quebec, then there is no option. The person will have to go through the program one of the programs that Quebec has, and satisfy the requirements of the government of Quebec in respect of the immigration programs that they've established, and then submit an application for permanent residence to Canadian government. Now, in terms of, there is a question quite often that immigrants ask if they apply to settle in one of the provinces, can they then move to another province? Yes, it's possible. There is mobility, right to mobility all around Canada for permanent residents. That's their right. The question arises where there is a concern that the applicant may not have intended to reside in a particular province. It's used that province to just get permanent residence in Canada. But again, those sort of discussions are beyond the scope of today's presentation, but it's good to keep those in mind as well. Okay, very briefly about inadmissibility when a foreign employer considers sending foreign workers to Canada, or Canadian employer is seeking to bring foreign workers to Canada. They would also want to consider whether there are any inadmissibility issues, how quickly and easily these foreign workers can enter Canada. So if people had some criminal matters in Canada or in any other country, whether they committed an offense or committed and got convicted for that offense, they may be inadmissible to Canada. And depending on circumstances, they may seek to resolve those matters on temporary basis, on a permanent basis. Temporary resident permit application would allow them to enter Canada temporarily and resolve their inadmissibility on a temporary basis, for example, to come to work in Canada. And the government would weigh the pros and cons, admitting them to Canada and the risks. And the other category that resolve the matter on a permanent basis would be criminal rehabilitation. Each application has its own set of requirements and eligibility, again, that goes well beyond today's presentation, but it's important to keep that in mind. Foreign workers might want to bring their family members with them to Canada right away when they travel to Canada, or subsequently after they've entered Canada, established themselves at least initially, and then bring their families with them. So who can benefit from such family status in Canada? Those would be spouses, common law partners, minor dependent children. And the types of status that they could get would be for temporary residence, visitor status, a worker or student. Quite often, a spouse would obtain an open work permit, and sometimes would prefer to go to school and university, college, and obtain a study permit instead. And then minor children sometimes would just need a visitor status, and in some cases, it's preferable that they obtain a study permit to study, as well as entering for temporary purpose. These family members may be joining the foreign workers or for foreign applicants to obtain permanent residence status. And so they can apply, and they normally do apply all together as a family to get permanent residence in Canada at that stage. And that completes my presentation. I went, well, quite a bit over our allotted time, but if there are any quick questions, I'll be happy to answer them. Otherwise, you could email them or contact me by phone. I'll be happy to answer those questions as well. These are law firm's details. Thank you very much for your attention. Again, thank you very, very much, everyone, for joining us today. And with that, I'll let Natalie say and Taras say a few final words. Thank you.
Muchas gracias, Joseph, por tu información y por tu presentación, toda la valiosa información que nos diste. Tenemos una pregunta, perdón, y dice, para construir una empresa comercial en Canadá con un socio canadiense, ¿qué tipo de visa requiero y qué tiempo puedo permanecer al año sin visa de residencia, sino como business program?
So that would depend on number of factors. The person would be seeking most likely admission to Canada on a work permit. In some cases, it's possible to use business visitor category, but it's unlikely that the scope of activity of such person would fit into that those requirements, and so work permit would be required. Then, in terms of type of work permit, if there is a way to structure this application or present the application based on the relevant existing factors as intercompany transfer, that can be a good way for such person to come to Canada and do business with that partner. They can create a corporation together, or this person may buy shares of that. Taras can perhaps say a few words on the way that can be done. That's within his domain. But in terms of the type of work permit, so it would be either intercompany transfer, or they might need to see if there is an exemption category other than intercompany transfer that would be suitable for this Canadian business, for example, to hire this foreign worker who would like to take part in that Canadian business with the partner. And if that's not possible, then they would need to seek labor market and impact assessment confirmation, on which basis a work permit can be applied for. I hope that answers the question.
Thank you so much for your answer, Joseph. I don't know, Taras, if you, perdón, muchas gracias por tu respuesta, Joseph. No sé, Joseph, Taras te mencionó, perdón, Taras, Joseph te mencionó, tal vez quieres añadir algo más.
Sure. What I would add is that you know, the process you know, can be a little bit complex, and so there are these three aspects to consider. It's not just so easy as, let's say, contacting myself and saying, okay, I want to start a business, and which one do you recommend? Because it is important that you, first of all, have consultations with your own tax accountant, you know, of your business to see what your financial position is and what some of the issues are. And then what we recommend is that you have a consultation with your tax advisors and with somebody like Sabina, so that you can make these decisions and say, well, which is the best structure for us? Should we do a subsidiary? Should we do whatever it shall be? And then we'll be able to create and set up the you know, the corporation, the structure that is going to be best for you. So it's not an easy answer. It's something that has to be thought about and considered and studied by you in consultation with your advisors. Thank you.
Yeah, and I'd like to add to that is that it's very important to speak to a business lawyer, corporate lawyer, as well as to immigration lawyer, in order to determine the best vehicle in terms of meeting the requirements ultimately for immigration purpose, even for temporary entry. It needs to be mentioned that in order to run a business in Canada, one doesn't necessarily have to have a work permit and be present in Canada. This business can be run remotely, but many people do choose to seek admission to Canada on a work permit, as it makes it easier for them to run the business. So quite often we would have a discussion with the corporate lawyer, between immigration lawyer and corporate lawyer, in order to determine mutually what would be in the best interest of a particular business applicant, having heard their goals and their intention and what their plans. We come jointly quite often with suggestions. So it's sort of a joint effort if, in addition to consulting the tax professionals on both sides, I would say, as mentioned, in the country where the person is from, or multiple countries where the person might have businesses in, and Canadian tax professional like Sabina, for example, and accountants as well. So I hope that answers the question as well. Thank you.
Yeah, and I'm just wondering if Sabina, if you are able to unmute and maybe can comment about just a little bit of the process that you go through. You know, a client contacts you for the first time, and sort of how do you start off with the client? You know, do you know, in terms of saying, well, how do you start the process with them?
So first we have to make a determination of the nature of the business that they want to carry on in Canada. So really, I think, like with all new clients, it's exploratory, an initial exploratory call to get a sense of what it is they're looking to do in Canada, and whether they are in fact already inadvertently carrying on business in Canada. That's often, it's very often the case where they don't realize that they potentially have tripped into a Canadian tax filing issue, and as a consequence, they sometimes have to play a little bit of catch up to restructure things or to set things up in a way that will be tax advantageous, and potentially also to deal with delinquent filings as a consequence of them in fact carrying on business in Canada and not recognizing that. So really it's just a matter of getting a sense of what the business is that is being carried on or proposed to be carried on, and then we can prepare a memorandum sort of setting out our recommendations in terms of so identification of issues, if there are already potential tax issues that have arisen because they are carrying on business in Canada inadvertently, or if we want to give them some guidance in terms of the proper way to structure. So we can prepare a memorandum, and then it's simply a matter of implementing the structure. And depending on the countries involved, we might need to have cross-border counsel involved, but that's essentially the process.
Thank you, Sabina.
Thanks, Sabina. Well, if there's no, perdón, muchísimas gracias. Y si no hay más preguntas, me gustaría agradecer a todos por asistir, escuchar y participar en el programa de expansión de negocios a Canadá desde América Latina hoy. Espero que se lleven consigo conocimiento nuevo y muy valioso. Me gustaría agradecer a nuestros patrocinadores Royal Bank of Canada, Sloan Partners Accountants y FlexServe, ya que su apoyo ha hecho posible el programa de hoy. Gracias a nuestros expertos oradores de Mills e InterJurisconsult, y gracias a la señora embajadora Sylvie Bedard por su presentación también, y también por la presencia y la presentación de Mauricio Ortiz, el embajador de Costa Rica. Si tienen alguna pregunta o desean comunicarse con Mills o InterJurisconsult, pueden enviar un correo electrónico a info@millsandmills.ca, y también a info@interjurisconsult.ca. Con esto concluye nuestro programa. Espero lo hayan disfrutado y les deseo un buen fin de semana.
Thank you, everyone.
Muchas gracias. Hasta luego.
Thank you, Natalie.